Hey guys, welcome back to the channel. Today we'll talk about commonly misunderstood contract clauses. Contracts are full of important provisions, but not all of them are easy to understand. In fact, some of the most crucial clauses are the most misunderstood. So today I'm going to break down the top 5 most frequently misunderstood clauses in contracts and clarify what they actually mean. First up is the force majeure clause. This clause often sounds dramatic, but it simply addresses what happens if unforeseen events, such as natural disasters, riots, or pandemics, prevent one party from fulfilling their obligations under a contract. It's often misunderstood as a get-out-of-jail-free card, and it doesn't excuse parties from all liabilities. It only covers specific events listed in the clause and doesn't usually apply to foreseeable challenges such as bad weather. Always check the exact list of events covered and be aware that force majeure doesn't apply if the event was reasonably foreseeable or preventable. Second most frequently misunderstood clause is the termination clause. Many people think that the termination clause simply means that they can end a contract whenever they feel like it. That's not the case. This clause sets out very specific circumstances under which the contract can be terminated, such as a breach of contract, insolvency, or by mutual agreement. Pay close attention to the conditions listed in the termination clause. You might not be able to walk away from a contract as easily as you think without facing penalties. Next up are indemnity clauses. Indemnity clauses often confuse people because of their complex legal language. Essentially, it's an agreement by one party to compensate the other party for any losses or damages arising from specific actions or events. Many people think that they will only be liable for damages if they are at fault, but in reality, indemnities cover even third-party actions through no fault of your own. Read this clause carefully to understand exactly what type of losses you might be responsible for, even if they are indirectly your fault. The fourth clause I'm going to talk about are confidentiality clauses. People commonly think that confidentiality clauses only apply while the contract is active. However, these clauses often extend well beyond the duration of the contract, requiring parties to keep certain information private indefinitely or for a period of time after expiry of the contract. For example, you have to keep the information confidential for 1 year or 3 years or 5 years after expiry of the contract. Always note the duration of your confidentiality obligations. Sometimes they last forever, even after the contract ends. Finally, the liquidated damages clause. This clause is often misunderstood as an automatic penalty. However, it's not about punishing the defaulting party. Liquidated damages are a pre-agreed amount to be paid if the contract is breached. The key is that this amount must be a genuine pre-estimate of the losses suffered by the other party in the event of a breach, not an arbitrary figure. If it's excessive, it might be considered a penalty and struck down by the courts. Ensure that the amount specified in the liquidated damages clause is reasonable, or it could be unenforceable. And there you have it, the top 5 most frequently misunderstood clauses in contracts. It's essential to fully understand what these clauses mean before signing anything. Contracts aren't just about formalities. They lay out the rights and obligations of both parties and can have serious legal consequences. If you are unsure about any clause in the contract, it's always wise to consult with a lawyer. If you found this video helpful, don't forget to like, share, and subscribe so you never miss a new video on legal tips and insights. Thank you for watching, and I'll see you in the next video.